Hi there. I'm Christine, and this is the Canadian Constitution Foundation's Freedom Update. Today, I want to talk to you about the right to freedom of assembly and the different ways that it's been interpreted by the courts and how it has been impacted in the last 2 years during the COVID-19 pandemic. Now, you may be surprised to learn that the right to freedom of assembly has actually received very little treatment from the courts in Canada. And I'm going to tell you why in this podcast and whether the COVID-19 pandemic has changed any of that. If you're new here, welcome. My name is Christine Van Gyn, and I'm the litigation director for the Canadian Constitution Foundation, a Canadian legal charity that fights for fundamental freedoms in Canada in the courts of law and public opinion. I upload regular videos about our ongoing cases and other interesting developments in constitutional law in Canada. So if that sounds like something that would be interesting to you, please hit like and subscribe below. It really helps my videos out a lot. And also, if you ring that little notification bell, you will never miss one of these updates. Also, please remember that these videos are for your information purposes only. They are not legal advice. If you have your own legal question or problem, please consult your own lawyer. So today I want to talk about freedom of assembly in Canada. The right to peaceful assembly in Canada is protected under Section 2C of the Canadian Charter of Rights and Freedoms. It's also protected in another document called the Canadian Bill of Rights, which is a mere statute. It only also applies to the federal government. And it's also protected in Article 21 of the International Covenant of Civil and Political Rights. The Supreme Court of Canada has referred collectively to the Section 2 freedoms, which are freedom of conscience and religion, freedom of thought, belief, opinion, expression, including freedom of the press, freedom of peaceful assembly, and freedom of association. The Supreme Court has referred to all of those rights as protecting rights fundamental to Canada's liberal democratic society. But freedom of peaceful assembly under Section 2C of the Charter has actually received really only limited judicial interpretation. The Supreme Court has not articulated any framework which freedom of peaceful assembly claims can be resolved through. And until recently, there has been almost no scholarship or very limited scholarship on the purpose and scope of Section 2C. In fact, Section 2C, the right to freedom of assembly, has often been treated as a derivative right of the right to freedom of expression. In fact, you'll see this in a lot of the decisions where Section 2C, freedom of assembly, is argued. The court will be asked to rule on an issue related to both freedom of assembly and freedom of expression. And the court will often say that the question can be resolved as a freedom of expression issue, and there's no need to do a freedom of assembly analysis. Now, in a way, this does make some sense since freedom of assembly is often at play during gatherings that are inherently expressive, like rallies, protests, demonstrations. But the pandemic has showed that freedom of assembly can be limited in new ways and ways that previously might have been unexpected. So there are sort of two broad themes that I want to talk about. First, there have been restrictions related to the pandemic to large outdoor gatherings like protests. But second, there have also been restrictions to even small private gatherings that are often social in nature. So this video today is going to be about protests, and I'm going to do a follow-up video about freedom of assembly for other gatherings like those private social gatherings or gatherings for sort of hybrid purposes. I was originally going to do this all at once, but it ended up being too long already. So in terms of protests, the right to freedom of assembly is a core right in a liberal democracy. People in a democracy have a right to protest. And if we allow too many restrictions on this fundamental right to demonstrate in the public streets, we end up silencing a lot of voices in our society, especially voices of people who might have limited means of otherwise making their views known. And a democratic society should welcome debate and disagreement on the key issues of the day. And a protest can be a really important and significant part of that process. Now, protests also can be really messy, they can be disruptive, but they are really crucial to our well-being as a functioning liberal democratic society. So I'm sure you all remember that there were extended periods during the pandemic in Canada where protests were technically not permitted. And a number of provinces, including Ontario, where I live, there were gathering limits that included restrictions on outdoor gatherings. There were protests where tickets were handed out to the protest organizers or participants for violating public health restrictions. This didn't just happen in Ontario, it happened in other provinces as well, including British Columbia and Alberta. For example, in 2020, there were several people who were given $1,200 tickets when they took part in an anti-restriction demonstration at the Alberta legislature. Those tickets were ultimately withdrawn. There were also anti-lockdown protesters who were ticketed in Alberta in May of 2021, but that incident was slightly different, different facts, and there was actually an injunction in place in that case. So that makes the facts of that case a little bit different. In Ontario, we at the Canadian Constitution Foundation represented a lone protester in Kingston who was given a ticket for protesting lockdowns. He was all by himself with a sign in a mask outside of Kingston City Hall. His ticket, thanks to our work at the CCF, was ultimately withdrawn. But I'll note that his protest, because he was by himself, would not actually fall under freedom of assembly because you can't assemble alone. But there could potentially have been an argument that his protest was an invitation to assemble, but we never got there. There were also many protests across Canada that occurred in the face of these gathering restrictions, but didn't have tickets issued. For example, there were large weekly protests in Toronto, and also there were a lot of protests in Montreal related to public health lockdowns and opposing those lockdowns. And tickets were not routinely handed out at those protests. Those protests were not shut down under the guise of public health restrictions. There were also protests related to farming policy in India earlier in the pandemic. There were protests in many major cities across Canada related to Black Lives Matter and police brutality. And for the most part, these protests were able to occur without fines and without police shutting them down, even in cases where the protests were technically in violation of those public health restrictions. So there's actually been only very minimal development of the law on freedom of assembly throughout this pandemic. There was one case in British Columbia called Baudouin and BC, where the court did find specifically a violation of the right to freedom of assembly in the context of an outdoor protest in that province. In that case, the petitioner, Alain Baudouin, was an activist who had organized public protests against what he called an abuse of power by the government, and he was protesting what he called unnecessary and draconian restrictions by the government in the name of safety during the pandemic. The protests that were at issue in this case took place on December 1st, 5th, and 12th of 2020, and Mr. Baudouin was issued a ticket for violating public health gathering restrictions in British Columbia. Now, he argued that the protests were peaceful political events that occurred outdoors, but the RCMP had been telling Mr. Baudouin at these protests not only that they were a violation of the public health restrictions, that he was going to be required to record personal information of the people attending the protests and threatened him with penalties for noncompliance for that. Mr. Baudouin explained that not only would it be impossible to collect the personal information for people coming in and out of a large public protest, but he was also reluctant, probably understandably so, to collect and divulge to police the information of people who are protesting the government. Now, in fighting the restrictions that he was ticketed under, Mr. Baudouin argued that the government orders prohibiting the gatherings, in that case his protest, was a violation of the right to freedom of assembly. Mr. Baudouin was ticketed for the protests that occurred in December, But in February, the government changed the order so that they no longer prohibited outdoor assemblies for protests. And in changing the order, the BC Public Health Officer, Dr. Bonnie Henry, included a new preamble to the updated public health order. And that preamble said, and I'm going to read it for you and I'll put it on the screen. When exercising my powers to protect the health of the public from the risks posed by COVID-19, I am aware of my obligation to choose measures that limit the charter rights and freedoms of British Columbians less intrusively where this is consistent with public health principles. In consequence, I am not prohibiting outdoor assemblies for the purpose of communicating a position on a matter of public interest or controversy, subject to my expectation that persons organizing or attending such assembly will take the steps and put in place the measures recommended in the guidelines posted on my website in order to limit the risk of transmission of COVID-19. So first, this is interesting to me on a few levels. The logic, I think, could, of course, be applied to outdoor gathering restrictions and enforcement against protests in other provinces. And I think that this should have been clarified in other provinces. Second, I wonder about the caveat in this preamble that gatherings would be permitted, but only for purposes of communicating a position on a matter of public interest or controversy. So the government here is saying that gatherings for protests outdoors would be permitted, but not outdoor gatherings for, other purposes like birthday parties. So this is the kind of two themes of public assembly and COVID restrictions that I mentioned at the outset of this video, and I'm going to touch on what those private or hybrid gatherings might mean in my next video. So in this Baudouin case, the regulations did change to make the protests that Mr. Baudouin had organized permissible, but it didn't change the fact that he was ticketed under the previous regulation. The government ended up conceding during the hearing itself that the order he was ticketed under, the order that prevented outdoor gatherings, including protests, that regulation was of no force or effect. The court did make a declaration that previous order did infringe his Section 2C rights to freedom of assembly, but there was no analysis since it was conceded. So while this right, freedom of assembly, was treated and acknowledged as its own separate right, not just a second order right to freedom of expression, there was no further analysis. So we don't really have a very meaningful development in the law, which for Section 2C remains still pretty undeveloped. Now, a lot of people have written to me about the Freedom Convoy protest. And I think that's probably why a lot of you might be watching this video. You want to know how the right to freedom of assembly, how that right was at play at the Freedom Convoy protest across Canada and specifically in Ottawa. And that's because that was, a really high profile situation. So I'm going to talk about those truck protests in Canada and in Ottawa. But first, I think we need some background and to talk about the police's approach to protests and how it changed over the last 10 years and how we really got to what ultimately happened in Ottawa. Now, a friend of mine, Professor Ryan Alford, has actually written about this topic specifically quite recently. He's written in an issue of Inside Policy magazine, which is a magazine produced by the Macdonald-Laurier Institute. Hi to all my friends at MLI. So Professor Alford has written about sort of the historical context leading up to what happened in Ottawa, because a lot of the commentary around what happened in Ottawa was that the situation was able to escalate to the point where it did, where the trucks were quite entrenched and had been there for quite a long time and had a lot of resources funding the protests, fueling the protests, that they were able to get there because of a kind of hands-off approach to policing at the very outset of the protest. So Professor Alford has written that in order to understand why we have seen a sort of less heavy-handed public order policing when it comes to protests, we really need to consider the historical context. Professor Alford has written about the impetus of this change in policing that led to a more hands-off approach. That impetus was the anti-globalization protests of 2010, in particular they led to this sort of change in policing policy. Now, I don't know how many of you remember those protests. I was actually living in a dorm at U of T at the time, and all of the students who were living there were temporarily kicked out of our residence. And I had a summer job, and my office was shut down as well during the protests. No one could get into the building, which was right at the corner of Bay and King, and the protests were completely wild. I don't know if you recall all of these images, but I remember watching on TV a video of a police car in front of my office on fire. But equally wild was the government response to these protests. The public saw clips of police officers with obscured badge numbers beating a defenseless man. They saw interviews with bystanders who had been swept up by the police in a strategy called kettling, where police box people in on a public street, in this case for hours. And we even saw footage of the police harassing journalists. The police conduct at those G20 protests in Toronto in 2010, they shocked the public. It shocked me as a committed civil libertarian. And ultimately, the Toronto Police Services Board was sued and settled a lawsuit brought by those who were arrested for $16.5 million. So Professor Alford has written that the events around the G20 produced a backlash that set a pattern for about a decade of a more hands-off approach to protest by police. Police focused instead on de-escalation, and in the views of many, this approach, it may have allowed the pendulum to swing quite far in the other direction. Because as a consequence, we've seen a lot of protests recently that have gotten quite out of control. The Charter protects the right to peaceful assembly. It does not protect riots and gatherings that seriously disturb the peace. It's also long been stated by the courts that the right to freedom of assembly, along with freedom of expression, do not include the right to physically impede or blockade lawful activities. So this brings us to some of the more recent high-profile protests where police used this newer hands-off approach. And a really notable example was in early 2020, before the pandemic had arrived in Canada. There were protests of the construction of the Coastal GasLink pipeline that ended up repeatedly blocking roads and ultimately rail lines. In February of 2020, protests across Canada took place, blocking those rail lines, including Via Rail passenger lines, and Via ultimately suspended basically all of its passenger service due to multiple blockades. The blockades were dangerous and they put people's safety at risk, and they also disrupted freight rail, which had some serious consequences. For example, it resulted in some propane and chlorine shortages in rural communities. Now, this all led into the pandemic, where we started to see protests that were occurring in spite of public health restrictions with in a lot of cases, limited police response. Now, while this wasn't true across the board, as I mentioned, it was notable that there were tickets being handed out at protests related to lockdowns. Many protests, even during lockdown periods when there were gathering restrictions in place, many of those protests did not receive police enforcement. Really notably, there was an incident in Ottawa where there were about 20,000 people protesting in support of Black Lives Matter. And the Prime Minister joined this large crowd and took a knee at the protest. And this all occurred in spite of many health restrictions that were in force at the time. Now, I want to be really clear. In saying this, I am not criticizing the police for failing to enforce those gathering restrictions at that protest or at any of these protests. In fact, I think to the extent that gathering restrictions that prohibited public demonstrations were in place, those were likely unconstitutional, as we saw in the Baudouin case. Although that ultimately was conceded, there was no analysis. The government did concede that the restriction on protests outdoors, that restriction was of no force in effect. I'm also not commenting on the content. I'm actually quite supportive of protests against police brutality, like those Black Lives Matter protests. And I'm also very supportive of protests against Canada's historic and terrible record of residential schools. We saw a lot of protests about that as well. I think that those protests are valuable and that the police shouldn't stop them. I also have a lot of sympathy for the cause. That said, I also have a lot of concerns about lockdown measures. And I think that those protests, a lot of the anti-lockdown protests, also served a really valid public purpose and had really important expressive value. And I share a lot of the frustrations around lockdowns. And I think police shouldn't stop those protests either. What I think is improper is that it appears as though enforcement measures in the name of public health were that enforcement was inconsistent. It looks like enforcement was done depending on the purpose of the protests, and that there was a lot more enforcement against anti-lockdown protests than other types of protests, at least in the name of public health and gathering restrictions. In terms of the purpose of the protest, the right to freedom of expression is content neutral. The protest shouldn't be stopped on the basis of the purpose. The police should apply a consistent standard to all of these protests in order to preserve our constitutionally protected right to free expression, freedom of assembly, and also to preserve the rule of law. So all of this background now leads us up to the Freedom Convoy, the trucker protests of early 2022. Like all of these other protests that I've talked about, the people who made up the Trucker Freedom Convoy have a right to freedom of expression and freedom of assembly. There's nothing remotely novel about driving to Ottawa to protest. It's how many people protest. And the Trucker Convoy and the thousands of Canadians who joined it, who are also fed up with mandates and lockdowns, they have every right under our Constitution to go to Ottawa to hold that protest. And as I've said, I'm pretty sympathetic to those frustrations of continued lockdowns and restrictions that were a part of that protest. Now, all of that said, protests that break laws can be shut down. The right to protest, covered by Section 2B, free expression, and 2C, free assembly, of the Charter, it can be subject to reasonable limits, like time, manner, and place restrictions. And there's a balance to be struck, of course. There may be bylaws and regulations that are in place regulating, for example, the use of public space, the use of the road, and these bylaws may be completely proper, and the protests may be in violation of those bylaws. But while the regulations may be proper and justifiable in most contexts, they may not be a reasonable limit in the context of a demonstration. It may be improper for police to try to shut down a protest for a minor bylaw infraction, depending on the circumstances. These bylaws and regulations may sometimes need to give way so that demonstrators can have their voices heard at a public protest. Demonstrations shouldn't be suppressed in the name of a minor bylaw that may not be a reasonable limit on the right to freedom of assembly and expression in that context where there's a large demonstration going on. Blocking an intersection by leaving a vehicle parked there while, for example, demonstrators are having a parade, that's a really common tactic, and it is an acceptable tactic. Police taking enforcement measures against the vehicle, against the owners of the vehicle, in the name of a parking bylaw, that wouldn't be an acceptable limit on the right to freedom of assembly and freedom of expression. But blocking roads for days on end, taking enforcement measure against that probably is a reasonable limit on expression and assembly. Another example is honking. Honking horns during a demonstration is pretty acceptable. Protests are noisy and disruptive. And in fact, they need to be noisy and disruptive in order to have any effectiveness. If police handed out noise ordinance tickets for a parade downtown because it was too noisy, that likely would not be a reasonable limit. But at some point, constant honking can be enforced against and be a reasonable limit on the right to demonstrate. There's no bright line rule on when a totally acceptable and legal protest becomes illegal and unacceptable. It's a contextual analysis. Now, these were, of course, tactics that were used by the Freedom Convoy, which was parked in downtown Ottawa. But these questions are all fact specific, so there are limits. So while a vehicle during a public demonstration could be parked on a public street or could be very noisy, it can't remain there indefinitely as part of a protest. Ultimately, the city will be justified in having that vehicle removed. And that was the case in Ottawa. Ultimately, these trucks had become entrenched, and it was reasonable at some point to remove them. It's also important to acknowledge that individuals who participate in protests may commit offenses. So while the act of protesting itself is protected, individuals who break laws, they can be prosecuted. While civil disobedience can be a part of expression and communicating a political message, it can still attract the possibility of prosecution, and protesters need to be aware of that risk when they choose to engage in civil disobedience, especially if that disobedience involves behavior that violates the criminal code, like, for example, the destruction of property. The ability of police to enforce the criminal code in the context of a protest is really important for the rule of law in Canada. The best way of doing this is for police to prioritize during protests the prevention of violence and prevention of destruction of property by enforcing the law against individuals, not by attempting to shut down non-violent protests wholesale. In the context of the Freedom Convoy protests, the protests were constitutionally protected speech and assembly. And although the protracted nature of the demonstrations ultimately did warrant law enforcement taking measures, for example, to remove the vehicles, up until a point, those were legal protests. A lot of the commentary around the beginning of the protests saying these were completely illegal protests, I mean, you could say that about almost any protest that takes place. Many protests that take place violate bylaws and space regulations. In the Ottawa case, it was really the protracted nature of those violations that created the issue. Now, the Ottawa situation is separate from the Freedom Convoy blockades that blocked major infrastructure and border crossings. So, as I stated earlier, the right to freedom of assembly, along with the right to free expression, doesn't include the right to physically impede or blockade lawful activities. Another important point to make is that the conduct of some individual protesters at the Freedom Convoy likely did warrant criminal charges for mischief, which ultimately were laid. Although certainly the police had that power under the criminal code all along, and there was no need for the federal government and the prime minister to invoke the Emergencies Act in order to lay those charges. I also want to briefly comment on the disruptiveness of the protests, where air horns were being blown for hours on end, including late into the night, and the disruption that people who lived in certain neighborhoods, especially in downtown Ottawa, were living with. Now, the fact is that protests can interfere with bystanders' rights, and that doesn't make the protest unlawful. The ability of a bystander to walk unimpeded on the sidewalk or even have quiet enjoyment of their home, protests can disrupt that, and that doesn't make the protest illegal. And the convoy protests were extremely disruptive. The air horns and I also saw footage of fireworks that were being put off at night. And this went on for a very long period of time. And I have no doubt that it was very distressing for people who lived in downtown Ottawa. I actually have a friend who lives downtown, and they have a baby, and sleep became really impossible for them during these demonstrations. And I think it's someone who would otherwise be pretty sympathetic to the cause and the frustration of the protests, but really was very unhappy with the inability of his infant to sleep at all during this period. And I of course have real sympathy for his situation. But the fact is that protests can be disruptive, and even disruptive protests are constitutionally protected. But ultimately, when it came to the protracted noise from those protests, the residents of or some of the residents of downtown Ottawa were able to obtain a civil law remedy by suing privately. They obtained an injunction prohibiting the honking, which the police then enforced. I hope this gives you a good overview of freedom of assembly in the context of a protest, and even how that right works during a pandemic. Although, as I warned, a lot of the analysis does fall under the rubric of freedom of expression. It's sort of surprising that even in the context of a global pandemic, there was very little consideration by the courts of the right to freedom of assembly. In the next episode of the Freedom Update, I want to tell you about freedom of assembly and how that right was impacted during the pandemic, during another context, and that is private gatherings. So to make sure that you don't miss that follow-up, hit the like and subscribe button below and turn on the little notification bell. You can also visit our website. It's the ccf.ca, and sign up for our Freedom Update emails. We usually send an email alert when we have a new video on this channel. But more importantly, you will get updates about all of our ongoing cases, like our case in British Columbia challenging vaccine passports in that province. The hearing is taking place on April 19th and 20th. And we also have a case on healthcare choice in Canada. We're expecting a decision on that really soon, and I have a video outlining it that I just released last week. We also have many other cases that deal with issues like freedom of expression and property rights. So we're always doing really interesting work, and you can stay up to date about it by subscribing to our Freedom Updates at the ccf.ca/freedom updates. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.